Hi, everybody. I'm Andre Mamolia, President of the Law and History Society, and this is the second lecture in our series on the new history of international law. The goal of this series is to bring to campus scholars that have challenged the conventional wisdom on the history of international law in recent years. We hope that this series will also promote intellectual cross-fertilization among the diverse group of historians, some working in history departments, some in law schools, to bring about something resembling a discipline. So we are making history in a sense. We're bringing about the new history of international law as we speak. In reaching these goals, the Law and History Society has received generous support from the Center on International and Comparative Law, the International Law Society, and the International Human Rights Law Society. Those of you who have missed out on the inaugural address to the New History of International Law lecture series can watch it on YouTube. Professor Moyne's lecture is there under the title Last Utopia. You can just search it. We are honored to have with us today one of the most distinguished scholars in the field of international legal history, David Golove, the Hiller Family Foundation Professor of Law at NYU School of Law, is the author of numerous articles, including such famous pieces as Treaty Making and the Nation, the Historical Foundations of the Nationalist Conception of Treaty Power in Michigan Law Review, Volume 98, Against Freeform Formalism in NYU Law Review, Volume 70, and Is NAFTA Constitutional in Harvard Law Review, Volume 108. Recently, he has been working on the Supreme Court, the War on Terror, and the American Just War Constitutional Tradition, as well as a paper called The Case for Incorporating Global Justice into the U.S. Constitution. He is one of the most thought-provoking scholars of his generation, and we are fortunate to have him in this series. Please join me in welcoming Professor David Golove.
Well, thank you for having me, and thank you for the very generous introduction. I'm going to be speaking today about a paper, that my talk today will be taken from a paper that I wrote that Andre just referred to, entitled The Case for Incorporating Global Justice into the U.S. Constitution. The paper arose out of the following experience I had. Many of you are probably familiar with the Supreme Court of the United States decision in the Hamdan case from a few years ago. For those of you who aren't, or those of you who don't recall, that was the case that dealt with the military commissions that President Bush constituted in Guantanamo for war crimes trials against some of the detainees that were being held in Guantanamo. There's been continuing and endless debate about the military commissions, whether they should be used. They're back in the newspaper with the announcement that some of the those responsible for 9/11 will be tried in civil court, Article III courts in New York. In the Hamdan case, the Supreme Court struck down the president's military commissions, and it did so without getting into any of the details. It did so because it found that, in part at least, it found that the military commissions that the president had organized are in violation of so-called Common Article III of the Geneva Conventions. Now, Common Article III of the Geneva Conventions, for those of you who aren't familiar with it, is a provision which sets out sort of bottom-line fundamental restraints on war measures in what is called non-international armed conflicts. The particular provision in Common Article III that the court found was violated by the military commissions provided something like a prohibition on criminal trials or the handing out of sentences and punishments without according a detainee those procedural rights, quote, deemed indispensable by civilized nations. That the procedures that the president had adopted did not meet the standard of being in accordance with those deemed indispensable by civilized nations. Now, in response, the Congress rather rapidly passed in late 2006 the Military Commissions Act, which probably, again, many of you are familiar with. And in the Military Commissions Act, now I'm simplifying greatly here, Congress, to a considerable degree, gave its imprimatur to what the president had done initially in organizing these military commissions. In that sense, it disagreed with the Supreme Court and reinstituted the procedures that the court had just held were not in accordance with those deemed indispensable by civilized nations. And it struck me, and I guess it's the origin of this project, it struck me as odd to think that Congress has the power to provide or authorize trials for criminal offenses that don't accord procedures that are deemed indispensable by civilized nations. Could that really be the case? Does Congress really have the power to do that? Now, a rather larger way of putting the point, and perhaps a grandiose way of putting the point, is the Constitution of the United States concerned with the subject of global justice? Or is global justice simply a subject that's outside of the concerns of the American Constitution? Okay, so that's the motivating question behind the project that I'm going to be talking about today. And as the title of the paper suggests, I want to argue that the U.S. Constitution ought not to be interpreted as unconcerned with and indifferent to questions of global justice as opposed to questions of domestic justice with which it's centrally concerned. Okay. Now, the paper, notwithstanding the series, the subject of the series, the paper is not, or the project that I'm working on is not, strictly speaking, a project about international law or the history of international law. Rather, it's about the history of constitutional law in the United States, but about that aspect of constitutional law that deals with international law, bringing the two subjects together. But it is fundamentally a paper or a project about constitutional law. Now, let me say a little bit about a larger project of which the subject I'm going to talk about today is really just a part. Because the part I'm going to talk about today is not really about history or law in a narrow sense. It's really more in the nature of a normative or a philosophical argument for the position that global justice ought to be incorporated in some respects into the American Constitution. But the larger project of which it's a part is very much historical in character. And it goes something like this. The claim of this paper is that the Constitution ought to be understood to incorporate some of the principles of global justice, understood as the actions of the government in respect of non-citizens, especially outside the territory of the United States. Now, the historical argument is an attempt to show that actually, historically, that was the case. That is to say, the Constitution was understood to be concerned with this problem in its origin and throughout the 19th century, although in the 20th century, this concern slowly waned until after World War II, it seemed to disappear altogether. Now, the historical claim, which is designed to motivate the normative argument, that is to show that the normative argument is talking about something that's connected to American constitutional history, not just something that I think is important, goes something like this. It points out that in the 18th and 19th centuries, there was a widely held theory of what I call public law, under which the world of public law was divided into two categories, at least for purposes of the protection of fundamental rights. Domestic justice concerns were part of the municipal law and were dealt with through the Constitution and especially the Bill of Rights. Questions of domestic justice were understood as being governed by the Bill of Rights. Questions of international justice or global justice were dealt with by the law of nations, which was the term that was then used for international law. The law of nations included the laws of war, which is a particularly part of the law of nations and global justice that I'm focusing on. Now, both the principles of the Bill of Rights and of the law of nations were understood as fundamental. They were rooted in natural law conceptions at the time. One wasn't viewed as morally more urgent than the other. The distinction between the law of nations and the Bill of Rights wasn't one that had a hierarchical character to it. Both were equally fundamental. Both were based on Enlightenment ideas. Nevertheless, the idea was that when Congress legislated with respect to U.S. citizens, it was governed in its legislation by the Bill of Rights. That was the mechanism designed to uphold concepts of domestic justice. And when it was regulating in the international sphere, it was not bound to follow the Bill of Rights, but rather it was bound to follow the law of nations. So that's the claim that the historical project, as in kind of broad terms, is trying to show, and to show how those ideas were developed in the late 18th century through the 19th century and how they waned, and some of the reasons why they waned in the 20th century. Okay. Now, let me turn now to the normative part of the argument, that part which I'm going to focus on today. There are really, I guess, there are two parts to the argument. The first part is a claim that the Constitution should incorporate concerns about global justice somehow, somewhere, into the Constitution. The Constitution should be interpreted to provide safeguards for the rights of non-citizens, even when they're outside the territory of the United States. Now, the second argument or claim that I make is that the most appealing way to accomplish this would be to adopt a kind of version of a traditional limited powers idea in American constitutional law, rather than finding that Congress's powers are constrained by the Bill of Rights in this area. That is to say that the concerns about global justice are incorporated into the Constitution through an idea of limits on the scope of congressional, say, war powers, so that congressional war powers are themselves limited by a concept of civilized behavior or just war conduct. And so they're limited, in the first instance, to measures which comply with that standard, rather than being general and then subject to the Bill of Rights as a way of constraining what particular measures Congress can make. Okay, so those are the two claims that I'll be trying to discuss and defend today. Now, let me begin by making just a couple of points about what I'm up to that qualify in some ways the general arguments I'll make. First of all, just a definition. What do I mean by global justice? And I'll come back to more about this in a minute. For now, as I've already indicated, I just mean, roughly speaking, the treatment of non-citizens. Okay, the global justice refers to, domestic justice refers to the treatment of citizens, and global justice to the treatment of non-citizens. Now, in contemporary United States, resident aliens are entitled to roughly the full panoply of constitutional rights, excluding political rights, although there are nuances. So the problem does not arise very much, at least, with respect to resident aliens. So what we're really talking about is the treatment of non-citizens outside the territory of the United States. And I think you can see, for those of you who are familiar with current debates in constitutional law, in the Boumediene case, that this topic is often described under the rubric of the extraterritorial application of the Bill of Rights. And one of the aims of this paper is to talk about the same topic, but to talk about it in a rather different way, hopefully a novel way. Okay, so that's what I mean by global justice, roughly speaking. Secondly, there are a number of ways in which global justice, so understood, could be incorporated into the concerns of the Constitution. Now, some of them are, you might say, procedural. So, for example, we might think that we should interpret the power of Congress to declare war and its relationship to the president's power to make war unilaterally without authorization from Congress. In thinking about that issue, we might think global justice considerations are relevant. Perhaps we think that if we insist that Congress has to authorize or declare war in every case, that will discourage the president from engaging in unjust wars or wars in violation of international law. I have no way object to that way of thinking about how to interpret the procedural or structural parts of the Constitution, but that's not what I'm focusing on here. What I want to focus on here is the direct incorporation of substantive limits on the behavior of the state, in this case Congress, that would apply. So, for example, the prohibition on torture, for example, as a directly incorporated into the United States Constitution as a limit on the war powers of the legislature and the president. So that's one distinction to bear in mind. A third point is that I'm not talking about global justice and offering an account of global justice, what the principles of global justice are. Those are, of course, highly controverted. I don't have my own theory of global justice to offer you, and if I did, it would definitely take up the full lecture. Instead, what I do is I assume that any plausible theory of global justice will at least recognize certain minimum principles, very familiar principles, like the prohibition on torture, or the prohibition on aggressive war, or the prohibition on genocide. And those are the kind of principles I have in mind when I refer to global justice. And I should say more generally that the term global justice, I think, can be misleading here. This is not an argument that global justice in some undifferentiated way is incorporated into the United States Constitution. Rather, what I'm thinking about, it's actually a rather more minimal concern about whether the Constitution is at all concerned about global justice, at all, in any respect. But to the extent that global justice is incorporated, and I'll come back to this issue later, I have in mind incorporated in, with respect to certain very fundamental principles of global justice, which are widely recognized in international law. Okay. Finally, this is maybe a kind of methodological point, which is to say, but the argument that I'm making really comes out of this point, which is I conceive of the Constitution in instrumental terms rather than, say, intrinsic terms, the value of the Constitution. That is, I think of the Constitution as a legal mechanism or instrument for achieving certain ends. It's an instrument for achieving many different kinds of ends, but one important end is the end of justice. And I think we widely view the Constitution as an important legal mechanism for achieving compliance by the state or government with the demands of domestic justice. The argument here is that we ought to see it also as an instrument for the achievement of global justice. And the argument in favor of incorporating global justice into the Constitution is really, in this respect, quite simple. Maybe it's even simplistic. At least I worry that it might be simplistic, which is just that we should incorporate global justice concerns, to some extent at least, into the Constitution, because or to the extent that doing so, will enhance the capacity of the United States to comply with the demands of global justice that apply to it, especially in view of the fact that developments in international relations suggest that the capacity of the international system to enforce international justice is weaker today than it may have been in the past. And I'll come back to that point later. Okay. So now let me flesh out this argument a little bit. And let me do so by offering 4 arguments, sort of stylized arguments, that I take to be the main arguments against incorporating any of the concerns of global justice into the Constitution. Okay, so I'm going to address 4 arguments. I'm going to make them for my opponents, and then I will then defeat them. Okay. The first argument I call the argument from popular sovereignty. And I think this argument, in one form or another, is quite common, with the idea being that there's something about incorporating international law in particular, but global justice in general, into the Constitution, which somehow violates the foundational principle of the American Constitution of popular sovereignty. It's somehow, as it were, a foreign imposition on the American demos, the American democratic electorate, that it would be undemocratic or against the idea of popular sovereignty to find in the Constitution principles that protect against violations of global justice. Now, there are a lot of things one can say about this argument. I think the most fundamental is that it simply misconceives what popular sovereignty is or can possibly justify. Unless popular sovereignty is the only principle of justice, then popular sovereignty has to be balanced against other considerations, other fundamental considerations in the making of a constitution. And a constitution which, let's say, affirmatively licensed the state to violate principles of global justice would simply be an unjust constitution, because it's almost tautological to say there's no argument in justice for violating the just rights of others. So popular sovereignty just can't do that work under, I think, any plausible conception of popular sovereignty. The argument, I think, more plausibly is that the American Constitution should be interpreted because of the principle of popular sovereignty in accordance with, well, there's an originalist version of the argument, with whatever it was that the people had in mind when they adopted the Constitution initially, and that that's a reason not to interpret the Constitution to incorporate principles of global justice, because the people didn't do it. And that it would therefore violate popular sovereignty. Well, there are a lot of problems with that argument. The one I just want to point out right now is it just assumes the conclusion as the premise of the argument, because the question is how best to interpret the Constitution when the Constitution itself is not clear, when there's room to interpret the Constitution in more than one way. And of course, the burden of the historical argument that I referred to at the beginning of my remarks was to show that actually, in its origins and for quite a considerable period of time, global justice considerations were incorporated into the Constitution, so that to argue from popular sovereignty and originalism against this view is not persuasive. Okay. The second argument is what I call the argument from sociology or from associative obligations. And so there are two versions of this argument, the sociological version and a kind of normative version, the associative obligations version, which is associated with the work of among others, Ronald Dworkin. Not that he makes the argument in this particular way, but it works with his idea of associative obligations. So the argument is, the sociological argument goes something like this. The foundation of the legitimacy of the modern state of let's say of the United States government depends upon the Constitution being a kind of focal point for the loyalty of citizens to the state. That without that kind of loyalty that's generated by a kind of the feeling of patriotism that comes from attachment to the Constitution, the state's foundations would be undermined. And the argument then goes one step further and says the idea of the Constitution as extending rights, or constitutional rights if you want to call them those, to aliens who may even be enemies of the United States trying to destroy the United States, who are outside the United States, is in conflict with this sociological purpose of the Constitution. Citizens are being asked to consider the Constitution in a way that's too encompassing, too inclusive. It's like turns the Constitution into the Universal Declaration of Human Rights, and thereby will undermine its foundation for this important function that it serves sociologically. The more normative version of the argument goes something like this. The legitimacy of the state in a philosophical sense depends upon an ideal of an associative community which recognizes members as having special duties and obligations to one another and among the citizens. And the Constitution is the instrument which embodies those special duties and of equal concern and respect that citizens should show to one another. And if the Constitution does the same with respect to people outside who aren't part of the polity, who are not citizens, who are outside the country, it undermines its ability to serve this function, to give rise to associative obligations, and therefore the legitimacy of the state. I won't try to explain this argument in any more depth. It's a complicated philosophical argument. I'm going to simply say that in response to both, it seems to me that the argument is way overdrawn. That is, the fact that the Constitution concerns itself with the rights of those outside the country who are not citizens of the country hardly means that the Constitution applies the same way to aliens outside the country and enemies as it does to citizens. It does not undermine special obligations that the Constitution creates, nor will it undermine the capacity of the Constitution to serve as a kind of focal point for loyalty to the state. Okay. The third argument is based on the constitutional theory of Professor Larry Sager, who's the dean at University of Texas Law School. He distinguishes between what he calls the realm of political justice, the realm of constitutional justice, and the realm of the judicially enforceable Constitution. Three categories, each one narrower than the other. That is, political justice includes all the principles of justice, whereas the realm of constitutional justice is narrower than the realm of political justice. He uses the example of distributive justice. principles of equality in the distribution of resources. You might think that justice requires a more equal distribution on some accounts than perhaps we have in the United States today, a distribution of income or resources. But although that's a question of political justice, it isn't a question within the domain of constitutional justice. Constitutions don't appropriately see themselves as not dealing with the problems of distributive justice. It's not a problem of constitutional dimension. And even less is it a problem that could be enforced through the judiciary. To the extent that there's a justice problem, it's not a judicially enforceable problem. Okay? So you get these three distinctions: political justice, the realm of political justice, the realm of constitutional justice, and the judicially enforceable constitution, each one smaller. And he makes a number of arguments about what fits in the category of only political justice, what could be incorporated into the domain of constitutional justice, what characteristics do a principle have to be judicially enforceable. And I simply want to say that I think that historically that one of the reasons why international law and global justice was not seen as incorporated into the Constitution by some was because of these kinds of concerns that are relevant to whether or not the principles of global justice are appropriately brought into the domain of constitutional justice or judicially enforceable constitutional justice. They don't have the right structure. They don't have they can't be cast in the right form so that they're appropriate to be part of the Constitution or part of the domain of the judicially enforceable Constitution. Now, I'm going to come back to explain why that is in a moment when I talk about what I take to be the argument, what I call the argument from the division of labor. Okay, the argument from the division of labor goes something like this. And again, I think that this in combination with the last argument are probably what underlies many of the people's intuitions about why perhaps international or global justice ought not to be part of the Constitution. Now, the argument from the division of labor goes something like this. Both domestic constitutional law, the Bill of Rights, and international law, the law of nations, are two old systems of law that deal with the problems or questions of domestic and global justice. And there's an appropriate division of labor between them. Constitutional law appropriately deals with subjects of the justice with respect to citizens. International law appropriately deals with the subject of justice with respect to non-citizens. The two are very different in structure and in content. They're appropriately governed by two different legal regimes. The two regimes shouldn't get in each other's way and confuse matters. They should be just treated in this way separately. They're just two different domains. And there the two shall meet. Okay, so now, Why is this a plausible view? What's persuasive about this idea of a division of labor? Well, in part, what's persuasive, I think, about it is that international law or international justice or global justice and domestic justice have a very different structure. And you see this in the way that international law and domestic constitutional law work. So they both have very different systems of enforcement. Right? The enforcement system of constitutional justice, understood as the way that the state treats the citizen, is the institutions which uphold and bring about compliance are relatively familiar. We think of judicial review today. The framers probably thought that judicial review would play a lot lesser role than we do today. Today, the court plays a large role in enforcing the domestic constitutional justice. The separation of powers, structure. Most of the ideas were structural. The separation of powers, federalism. This is Madisonian theory in the Federalist Papers. The double security that comes from the separation of powers and federalism, electoral accountability to the citizen, and so on. There are a whole set of mechanisms which tie the government to the people, divide power in a way that gives government officials the right kinds of incentives to respect constitutional rights. Now, what are the mechanisms that enforce global justice historically? Well, the balance of powers between states, which has an analogy to federalism in the United States. The principle of reciprocity plays a very great role, tit for tat. International law was enforced by the ability of one state that felt its rights were violated to take reprisals against the other state. Okay. Now, there were important consequences to the differences between international law and domestic law in this way. So, for example, the principles of global justice, well, the principles of domestic justice have a kind of, in the Bill of Rights, have a kind of absolute character, non-contingent character. The state always has to comply with the principles of the Bill of Rights. That's a basic idea. And the Bill of Rights are designed to individuate guilt and responsibility, right? When the state punishes, much of the principles of domestic justice apply to how the state goes about determining who's committed offenses and how those offenses will be punished. And due process is a central idea in that context. Global justice concerns are necessarily collective in nature. It's about the interactions between collective bodies. And the rights which international law historically recognized, as for example in the law of war, were not absolute but contingent because of the idea of reciprocity and tit for tat, right? So it used to be widely recognized that if one state during a war mistreated the prisoners of war of the other state, of the other belligerent party, it was perfectly consistent with justice, global justice, for the other state to take reprisals against prisoners of war being held by it, of the other state. Now, we don't do that today, and we'll come back to that in a minute. But that was understood to be central to the way international law operated, the idea of reciprocity and tit for tat. That made the rights that international law recognized contingent. Because they were contingent, and this goes back to the point about political justice, the domain of constitutional justice, and the judicially enforceable constitution, because the rights were contingent, they were contingent on the conduct of another state. It was always a question whether or not a state had to comply with global justice principles in any particular case, because it depended upon the actions of the other state. If the state had acted in a way that violated the principles of justice of one's own state's nationals, then it was legitimate not to apply the principles of global justice to the nationals that one had in one's own custody. Okay, so there was this difference. And now that difference relates, you can see how it relates, for example, to judicial enforcement. Because the judiciary, even if a principle of global justice was appropriate for judicial enforcement in principle, how would the judiciary be able to assess what the conduct of the opposing state was that might or might not justify not following the principle in any particular case? And we didn't have this problem in domestic justice, in domestic constitutional principles, which in that sense were non-contingent. Okay. Now let me say now why I think that the division of labor argument and the argument about the domain of constitutional justice and judicially enforceable principles is no longer justifies the separation between global justice and domestic justice into the Bill of Rights and international law. What's changed in the world that makes this division no longer seem, to me anyway, to be compelling? Well, there have been a number of changes in the world. So some of them are related to the attitudes towards the Constitution and international law, the contrast between them. So, as I said, in the 18th and 19th centuries, both systems of law public law were recognized as being founded on Enlightenment principles, natural law. They were equally fundamental principles of public law that governed the conduct of the state, in one case global justice, in the other case domestic justice. But in contemporary times, partly perhaps because of the demise of natural law concepts and the development of positivism for a number of reasons, today, although the Bill of Rights are still seen in the United States as embodying principles, the fundamental moral principles that the state has to comply with, international law has lost a lot of its luster in this respect. And there are many, many people in the United States who have doubts whether or not international law does, in fact, express fundamental principles of global justice that ought to be complied with, which means that global justice has become severed from any kind of a set of legal principles and left much more to the free play of politics without guidance from legal principles. Now, a second change, of course, is the balance of power has changed. So traditionally, as I said before, international law and global justice was enforced principally through the balance of powers. Without the balance of powers, the system of reciprocity, tit for tat, will not function appropriately. and the state may no longer be willing to comply with the demands of global justice in the way it would have had the balance of power system been operating the way it was historically expected to operate. This is a problem with respect to the United States in particular. The United States position has obviously radically changed from when it was a little tiny state in 1776 to today when it's the global hyperpower or superpower or whatever. And of course, that's had many significant changes in the way that the United States behaves internationally. To point out some ways in which this has eroded the way in which the international system was supposed to operate, take the principle of territoriality, which was one essential part of the global justice system. We have many examples now of the United States being unwilling to recognize the territorial sovereignty of other states. One of the most famous cases being talked about these days is the CIA officers kidnapping off the streets of Rome a suspect they believed to be connected to terrorism and rendering him to Egypt for interrogation. This was done, of course, in violation of Italian law and Italian sovereignty. In fact, Italy prosecuted the CIA agents in absentia for this violation, but the United States was unwilling to recognize the international law principle of territoriality. In other cases, the United States acts within the territory of other states with the permission of their officials, but it's more in the nature of a connivance between federal executive officials and executive officials of a foreign country who are acting in violation of their own law and their own constitutions. Another now obvious example of this is the Polish government, which allowed the United States to operate black sites on Polish territory, which were clearly in violation of Polish constitutional law as well as European human rights principles. Sometimes the United States now has a number of territories where it has completely ousted the local sovereign. Guantanamo is a perfect example of this, where it's not a territory of the United States, it's a territory that belongs de jure to Cuba, but Cuban law does not apply there, no Cuban institutions apply there, the territorial sovereignty of Cuba is absolutely irrelevant to the behavior in which the United States engages. It's not surprising it's that context in which the Boumediene case extended constitutional rights to Guantanamo. All right. Finally, well, two other points. The third point is the duty of protection. So part of the international system, the global justice system, was based on the idea of the balance of powers and the duty of protection. It was that the state had a duty to protect, the citizen had a duty of allegiance to its own state, and the state had a duty of protection towards the citizen. Without that, the balance of powers does nothing to protect people's rights, because if the state if your state doesn't come to your protection, then the system has no operation at all. One problem, one change that's occurred recently with respect particularly to terrorism is there seems to be, at least arguably, a kind of diminishment in the force of the duty of protection. One can understand this in the terrorist context. The terrorist phenomenon itself, contemporary terrorism, is a kind of transnational phenomenon where terrorists deny the validity of nation states and threaten all nation states equally, or at least many nation states equally, most especially their own, thereby undermining the duty of protection which the state would otherwise feel it owes to them. Now lastly is the change in the structure of rights in international law. Because this idea of reciprocity and tit for tat, the idea of the non-contingent nature of international rights under traditional international law has changed very dramatically, and partly as a result of the human rights movement. It's now the case that international law has all kinds of principles against reprisals on the person. It's no longer legitimate to kill enemy prisoners of war because the other side killed your prisoners of war. That's now seen as a fundamental violation of global justice. So the contingency of international rights that made them questionable for incorporation into the domain of constitutional justice and even the judicially enforceable constitution is no longer as prevalent as it was at one time, and enables these principles to be incorporated in the Constitution and enforced by the judiciary in some cases in a way that would not have been possible before these developments. Okay, so those are the changes that I want to point to that I say justifies why it is we would want now to incorporate global justice into the Constitution, at least to some extent. Okay, now let me just say a little bit about why it is the second part of the argument, and then I'll stop, which is, okay, let's say we take it as established that, that there are reasons to want global justice to be incorporated into the Constitution, like the Hamdan case suggests. Now, how should it be done? There's some technical questions here about, well, so where does it fit in the Constitution? Is it in the Bill of Rights? Should the Bill of Rights be extended extraterritorially, as some people have argued? Or if it's the Bill of Rights, is it all of the Bill of Rights? Is it just the Fifth Amendment due process? Or alternatively, and this is the alternative that I'm arguing for, ought to be done through a limited powers concept that makes reference to a standard of civilized behavior. Okay, a standard of civilized or just behavior that places limits on the powers of Congress with respect to, say, war or foreign affairs that are rooted in a concept of civilized behavior, which itself makes reference to international law. And the argument that I want to defend is that rather than applying the Bill of Rights extraterritorially, at least in the first instance, it makes more sense, it's more appealing, it's more justified to instead use this idea of limited powers and a standard of civilized behavior, okay, and tie that to the fundamental rights that are recognized in international law. That is, when a constitutional interpreter is asked to say what the Constitution requires of the United States government in this area, rather than reasoning by pointing to the Bill of Rights and trying to analogize a situation that's arisen to cases that can, you know, within the corpus of jurisprudence on the Bill of Rights, and then drawing analogies and so on to try to come up with an answer to what rights are protected by the Constitution in this area. That instead, courts or interpreters should look to fundamental principles of international law. The fundamental moral principles. So, for example, international law has lots of resources today for identifying what are its more fundamental principles. The idea of jus cogens, for those of you who are familiar with international law, non-reprisals on the person, Common Article 3, prohibition on torture, and so on. There are a number of concepts and legal mechanisms with international law which define the most fundamental provisions from a moral point of view. It's those that I say that interpreters should view as incorporated into the Constitution, at least prima facie incorporated. There are three basic arguments why in favor of doing it this way as opposed to doing it through, say, the Bill of Rights. The first is a kind of sociological argument, which goes back to the argument from sociology that I discussed before, and that is to say that it may be too too demanding on citizens to ask them to understand their Constitution as extending the Bill of Rights, constitutional rights under the Bill of Rights, not only to aliens, but to aliens outside the United States who've never been in the United States, and aliens who are outside the United States who are enemies of the United States, who are attacking the United States and trying to undermine its society. That's too encompassing a concept of the scope of the Bill of Rights and constitutional rights, but that rather demanding that citizens respect and understand an obligation to behave in a civilized fashion, to recognize the sort of claims of justice and in respect to civilized behavior of non-citizens is less demanding, and in fact is what we ought to demand, is what people ought to do anyway in order to have a just society. So that's the first argument, is that it's, from a sociological point of view, it makes more sense. It's less demanding and captures something better than the idea of extending constitutional rights. There's an epistemic sort of argument, which is that international law is made by the community of states. Its principles are less biased than you would expect the national authorities of any particular state to adopt, especially when they're engaged in conflict. That you would, if you want to get the right principles, you probably wouldn't want to ask somebody who's an interested party on one side of a dispute what the principles that govern their behavior are, but rather look to the general community to define what those principles are. And the third argument is a kind of substantive argument. The idea here is that the global justice, insofar as it's determined through a political process, what the content of global justice is, we ought to think of as belonging to global society, not to the society of any particular state. It isn't any particular state's constitutional tradition which should define what the principles of global justice are, but rather the community of states that have engaged in elaborate processes to try to define what those rights are together are the appropriate justifiable body for making those decisions about the content of global justice. So rather than looking to say substantive due process for whether or not torture of an enemy combatant is justified, or whatever kind of treatment, coercive interrogation is justified, and looking to the cases that the Supreme Court has decided on the scope of substantive due process and shocks the conscience of the court, and so on, the interpreter should look to international legal process to see what the international law standards that have been agreed to as fundamental standards with respect to the treatment of detainees provides for. So in that sense, the democratic argument that somehow it's undemocratic to be bound by what the community as a whole provides rather than what the national community decides for itself is misguided in this context, because it's not an appropriate decision for a national democracy to make how it will treat those who are not part of its polity, who are outside of its territory and engage in conflict with them. Rather, it's a decision more appropriately taken by the globe as a whole. Okay, so that's the basic argument. Let me just say make one other point, which is I believe that if you read the Supreme Court's decisions in the series of cases that have been decided over the past few years in the war on terror cases, beginning with the Hamdi Rasool cases and then the Hamdan case and more recently the Boumediene case, I think you'll see that actually much of what I'm suggesting is what underlies what the court is doing. I don't have time now to try to explain why I think that's the case, but I think when you think about what the court has been up to, you see how heavy a role international law has played in the judgments it's reached about what rights enemy combatants have or don't have in the context of the war on terror. And that, so that although it hasn't come out and adopted the idea that the Constitution, these are constitutional principles, it's found sub-constitutional principles for reaching these results, the underlying intuition or impulse seems to be quite consistent with what I'm suggesting is the way to think about this problem. Okay, great. Might have questions.
Professor Golub will now entertain your questions on the talk on global justice in the war on terror and his greater body of work.
Yeah.
You seem to point out that, or seem to kind of take international law and the international community as kind of an it, not a they, meaning that there's kind of one voice to listen to as opposed to many. What would you say? Would you say that that's an accurate representation? And if so, what are the problems with making the international voice one voice as opposed to many? Do you take the Western Judeo-Christian voice? Do you take the one that was, after World War II in many ways kind of created in some ways our institutions, or the Middle Eastern, East Asian? All of these have different ideas of justice and how to treat human rights and substantive rights. So which one do you listen to? Great.
So so is it a it or a they? Is it a pluralistic body of principles, or is there some unified body of principles? And I guess I think that for the purposes that I am writing about, we have to think about international law as unified. That doesn't mean that there's not a cacophony of voices and different conceptions of justice. It's more a reflection of how thin the conception of justice that I'm referring to here is. That is, I'm referring to those principles of international law that have been deemed fundamental within the discourse of international law, that are widely adhered to within the main instruments, which virtually every country in the world or every country in the world are party to. And I'm not referring now to the interpretive problems that arise as to how it will be determined in any particular case what the meaning of any, what these principles are. So while there's certainly much disagreement about many things, there's some core area of agreement on certain very fundamental principles, or at least greater agreement. And all I'm referring to at this point for these purposes is that small subset of principles. These are meant to be principles that are incorporated into a constitution, at least into the United States Constitution. So even there, the idea of fundamentality is part of the what is desiderata that one would apply for thinking about what's within the domain of constitutional justice, as opposed to what might be in the domain of political justice, or just within the discretion of the state decide how to behave with regard to. So I don't reject your view about international law. I don't think, but what I'm referring to right now is a limited core area where there is a widespread overlapping consensus of some kind as to what the principles are. I'm not really reaching for anything more ambitious than that. Does that help?
Yep.
Yeah. Kurt. Yeah.
Hey, David. So, equating global justice with at least what you're calling fundamental principles of international law, I can imagine you might get questions about how you really figure out what the fundamental ones are. You said in the discourse, and people can press you on that. But I have a different set of questions, more practical, which is, to what extent should we give weight to what international lawmakers themselves are doing on that question? So the Geneva Conventions, for example, very fundamental parts of international law, they actually give states an express right to withdraw, which seems to deconstitutionalize it compared to what you have in mind of making it kind of a permanent fabric of the international community. So prisoner of war convention, you can pull out on notice. And that's what states actually agreed to in the 1940s. So then I thought, well, what effect, by moving to your side of constitutionalization view of this stuff, would have on state behavior, say, on the next Geneva Convention? So I imagine this means the United States will never ratify the additional protocols, because if you're going to constitutionalize them and take away any leverage Congress and the President would otherwise have, it was hard enough to get the United States into these some of these treaties to begin with. You're just going to make it harder ex ante. And then it occurs to me that some of the hardest issues, say, on the war on terror, are ones where no one thinks, there's no agreement that international law has fully regulated it, right? There's a huge debate, and I think properly so, about whether the Geneva Conventions were written with the war on terror in any way applicable in mind. And if all the hard issues are ones where we don't have state agreements, then we don't have agreement on the fundamental principles, and so the constitutionalization shouldn't do any work unless the judges, if that's true that people are applying it, kind of get to have their own evolving notion of it, which would raise some different kinds of concerns about democratic legitimacy. So I wonder, just as a matter of practicality, how this is going to affect how states act and whether it's really going to solve some of the new problems that come up.
Right. So, of course, the problems you allude to, of course, are there. So I don't want to dismiss the problems. And of course, there's no perfect solution to these issues, one way or the other. There are costs and benefits to different approaches. So the first thing I'd say as to what I take to be your first point, that I'm not arguing for the constitutionalization of the Geneva Conventions, but rather for some limited set of principles that might be found in the Geneva Conventions would be a place to look to determine what they are, but not to lock, stock, and barrel find that all of international law, including all of the Geneva Conventions, all of the modern international humanitarian law or the law of armed conflict, is part of the American Constitution. So although that doesn't eliminate the problem, it narrows the problem substantially from the way that I think that you described it. And I think what you see, and this is responsive to your second, I'll bring this around to say, you see what the court has done largely thus far, for example, insofar as we're looking to the court for some guidance as to how this might play out in practice, is it didn't constitutionalize anything, but to the extent we want to leap forward and interpret the court in that way, they constitutionalized Common Article 3. Okay? So it was Common Article 3, they didn't constitutionalize it, but it was just go further and say that's what they do the next time when challenged sufficiently. They constitutionalize Common Article 3. Whether they call it the Bill of Rights and the Due Process Clause and find that somehow the Due Process Clause is just congruent with what Common Article 3 requires, which is what I'd rather expect that they would do. That may well be what they end up doing in Guantanamo, depending on how things play out in litigation and so on. I think as to the first point, that's what I have in mind, is the minimal principles that are recognized as fundamental. Now, to your second point, which relates back to Common Article 3, and which is, so what if it turns out international law has nothing to say? And my intuition is quite actually similar to yours about this, that I think the war on terror, I think the war on terror was a novel phenomenon, relatively speaking. And while it's possible to extend the principles of the laws of war, or the traditional laws of war, the Geneva Conventions, whatever, Common Article 3, to fit the case, it's a constructive enterprise by any account. Now, I know a lot of law of war people don't agree with that, but let's just stipulate that that's true. That was what I think underlies your remark. And say, so what do we do then? Now, you raise it as for the judiciary to step in, there's a democratic problem. So we could argue about that. There might be a democratic problem if you think that's a democratic, but it's a democratic problem when they step in for the First Amendment or the Fifth Amendment. There's lots of democratic problems if you think there are problems with judicial review. I don't see this one as being especially problematic. In fact, I tried to make the argument that this is an area where it doesn't seem to me democratic principles have as much sway as they would otherwise have, because it's not about the treatment of citizens. It's the treatment of non-citizens outside the state, where democratic principles are not as readily, in my mind, applicable. But yes, I do think that we may have a situation, we may find this happens frequently, depending on how committed you are to a kind of indeterminacy of law thesis, that when the new situation arises, actually international law and domestic law, for that matter, just don't have anything to say. There's nothing determinate to say. So what are we going to do then? Well, I think historically what's happened is that either the political branches or the court, or the political branches and the court together, have developed rules. They've extended the rules. They've figured out, they've used various analogies and principles and so on to try to fill in the gaps that they find in the law. I'd expect them to do the same thing here. But of course, it does mean that they're engaged in a more constructive enterprise. They move further and further from international law sources as such to creating international law, or engaging in a process of the creation of international law. I think that's inevitable. And I think it's quite plausible that's what the Supreme Court did in the Hamdan case, because as you were certainly aware, there were powerful arguments that Common Article 3 didn't apply. So now, as to the point about, which I didn't address, about the fact that states can withdraw, well, that's a very formal point, because states don't withdraw. And when you have, what we now have, we really have, not only for the 1949 Geneva Convention, really they didn't, the earlier Geneva Convention goes back further. This is a very, very entrenched regime, and it doesn't seem to me that to point out that states could, in theory, withdraw tells you that it doesn't have a fundamental status. That just doesn't seem to me to be too formalistic a way of thinking about it. Beyond that, most of the principles, and certainly these fundamental principles, are widely viewed as part of customary international law. They're still part of international. A state that withdraws can't avoid the application of these principles as a matter of international law. And so I would say the same with respect to constitutional law. I don't see that poses much of a serious objection. So, okay, yeah.
I thought I heard you say pretty early in your talk, you made a brief comment about just war. Now, if the congressional war powers were to be viewed as restricted in the way that you've talked about, who would have standing to say, bring a suit that a preemptive war was unconstitutional, and would it be thrown out as a political question?
So, right. So one thing I did not do, and it's kind of floated in and out, and it was in Professor Bradley's question too, and you've brought it out, is to say anything very strong about judicial review. So, and really the argument is not about judicial review, it's about the Constitution. That is, I assume that the Constitution has a certain status in American political life, that there's a certain moral authority attached to the Constitution. There are certain mechanisms which go beyond judicial review, but judicial review is one of them, which make constitutional rules and principles have a stickiness about them that sub-constitutional rules don't have. And so it's enough to say that this is a constitutional duty of the political branches that they have to observe. And I think historically, the political branches have understood themselves in that way, especially with respect to the law of war. I mean, the military, that's why it was the JAG lawyers that were most resistant to many of the Bush administration's policies with respect to detainees, because they had all been trained in a now ancient system, which was fully dedicated to the idea that the laws of war were the laws that governed what they did. They didn't have a choice. It was beyond their choice. It was, in that sense, a constitutional body of law for them. So that's important in and of itself. You ask about just war in the sense of the use ad bellum, and whether or not there would be judicial enforceability. Well, I mean, I don't have any particular view about it one way or the other. There has not been judicial enforceability of the constitutional division of separation of powers. So it would be surprising to find judicial enforceability now. On the other hand, we don't have any clear Supreme Court decisions to tell us why it's not judicially enforceable, and who knows? I mean, that is, I take the scope of judicial authority and judicial enforceability and justiciability to be a changing, organism. And there were certain concepts at the early period, and they changed in the middle period, and they changed again, they've changed again, they've changed many times. And there are all kinds of important arguments about what they ought to be, but I haven't engaged in any of those arguments yet.
One last question.
Okay. Okay. Great.